so we will start going live now. Okay. So we are now live and the case will begin to record. We are now recording. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is now open.
Okay, good morning, and thank you very much. Let me begin by introducing myself and the panel. My name is Ariane Buno. I'm joined today by Justice James Milkey and Justice Catherine Hand, and the three of us will be hearing your case today. Mr. O'Brien, just so you know, you have 15 minutes to present your argument. I can tell you that we've gone through everything you've submitted to us and everything that's been submitted to us also by Attorney Long, and reviewed everything. So you can get right to your points when you start your argument. I also want you to know that once you make your argument, there is no rebuttal. So after you speak, we'll hear from Attorney Long, and then the case will be taken under advisement by us. All right?
Thank you.
You're welcome. So I'm going to call the case officially. Edward S. O'Brien versus Charles King and others, 2023-0161. Mr. O'Brien, please go ahead with your argument.
Thank you, Your Honor. I'd first like to apologize to this court that I'm even here arguing this appeal in the first place. It shouldn't have even gotten this far. But I'm going up against a medical provider that has chosen profit over care. I'm a healthy man other than this issue. I didn't want to take the chance and have to challenge WellPath and its employees if, God forbid, I'm in a life-saving medical situation, because I see how they treat other prisoners in this system. My argument here today is that I believe that the motion judge erred in his ruling when he ruled in favor of the defendant's motion to dismiss. The motion judge relied on evidence that was not before him and gave the defendants the inference in their unsupported motion to dismiss arguments to rule in favor of dismissal over the well-established sufficient showing that should have given all reasonable inferences to the plaintiff, as mentioned in Cook versus Turco, 2020 U.S. District First Circuit.
Mr. O'Brien, could I ask a question? Your complaint does not, as far as I read it, specifically say that the sneakers that you were hoping to obtain were superior in their pain relief to the alternative method. Is that an inference that we should be drawing from your complaint, that the sneakers were more than just a choice between two equal treatments?
I would hope you would. I've dealt with the defendant, Dr. King, for over 10 years, 12 years, and we've gone through every stage for pain relief. And it got to the point where he prescribed these sneakers specifically to relieve my pain because everything else he tried didn't. When defendant Ryder became involved in this situation, she was only here for maybe a year or two. She decided to take money over care.
Can I just press you on that point?
Yes.
You said that WellPath is choosing profits over care. As I understand it, though, you were willing to pay for the specific sneakers you want.
That's correct.
So how does profit even enter into it?
Because the Department of Corrections came up with their own so-called policy that I never saw, that didn't allow me to purchase my own sneakers anymore, and they said WellPath would have to pay for them.
Yeah, but what I'm missing though is how profit enters that, as opposed to a DOC policy or a WellPath policy driven by other considerations.
I understand. So when the Department of Corrections changed their policy, they put the onus on WellPath to purchase the sneakers for me. They did once under Rebecca Petrie, it's in the record appendix. She was the former health service administrator before Kelly Ryder. When Kelly Ryder came in, she came in with a mission to save WellPath money here at NCCI Gardner. And one of her mission statements to her staff was to cut out supplying footwear for the patients here, for the prisoners. That order to her staff was a cost-cutting move. And even though I told WellPath I'd be willing to pay for these sneakers, they told us, you can't, and we're not going to pay for them anymore. So under her, the former HSA, I was allowed to pay for them. They paid for them, but under Kelly Ryder, she just said, we're not paying it, we're not wasting the money.
And that was, excuse me, just to clarify, a new directive that came across that applies to you and everybody else, that you could no longer purchase footwear independently. And I presume that means any kind of footwear, or is it just the specific type of footwear?
Just the medical footwear. The DOC said that if I was going to purchase medical footwear, that they weren't going to allow it because WellPath, the medical provider, should provide it. And then that's when they changed their order saying, we're not going to provide it anymore. And they were citing a policy that wasn't in place. And on record appendix 1, on page 128, I believe.
Mm-hmm.
Sorry, 126. After Kelly Ryder left, on the last sentence of the physician notes, Jesse Hammond, the physician assistant, stated that he will contact WellPath senior leadership regarding exceptions to current practice guidelines. So they adopted a current practice guideline at that time to not provide sneakers or footwear that were medically prescribed. Since Kelly Ryder has left WellPath, she's no longer an employee for WellPath, I've been receiving these sneakers. It was just her. WellPath said there was no policy. It was just a guideline. It was a practice. I contend that the practice was just to save money under Kelly Ryder. Since I've received the sneakers before Kelly Ryder and after Kelly Ryder from WellPath.
Mr. O'Brien, since the time you filed your brief, you have received the sneakers that were at issue in this case?
That is correct. And you can find that order on page 128 of my record appendix, the plaintiff's record appendix. I received those in December of last year, and I'm in line to receive another pair in the next month.
So putting aside the question of the damages that you were seeking, why is this case not moot? You have the sneakers that you wanted.
Because the mootness in this issue is as evident in the pleadings and in my papers, is their decisions are arbitrary and capricious. They could change tomorrow and say, oh, we have a new policy or practice where we're not allowing the sneakers or any type of footwear. Part of my pleadings is I would like to be ordered that they have to supply me these sneakers also. It's just arbitrary. Tomorrow they can just come in and say, oh yeah, we're not giving out sneakers. I was recently in the HSU for getting some shots, and an order came down that nurses only have to wear one glove now to give a shot because they're trying to save money on gloves. It's just every day it's something new with these people. And that's why I'm going to continue fighting this, because it doesn't change. It's all about money. It's not about care.
Well, you know, one of the problems that arises from that, you can well imagine, Mr. O'Brien, is that we can't really think about things that might happen in the future.
Right.
It's not. I guess it's pretty obvious why, right? So I don't need to elaborate upon that. But at this point, what relief are you seeking? In other words, you have the sneakers. So what is the relief to have your complaint reinstated so that you can pursue damages?
That is one avenue. That is one request. but I still would like to be able to have the court, the lower, if this gets sent back to the lower court, I would like the lower court to be able to order the defendants to keep this order for medically prescribed sneakers in my record.
Because of course that could change for you too. I mean, I'm not intimately familiar with your situation, but if the bone spurs or whatever, if something gets ameliorated, you may need something different than this, or you
That's
may
correct.
want this or whatever. So I don't think you're looking for an order that says you are to get these sneakers forever and a day, correct?
I'm about to, honestly, I have another surgery probably lined up in the next year because I have the bone spur coming through again. It's going to need to go in and get shaved off. So I can already see me dealing with those hurdles. And that is why I was asking for that. Who knows? It could change down the road, but I would just like to be able to be given proper medical care that the defendants have, well, at least Kelly Ryder has shown not to provide.
But
They're
you
in
said,
cost-cutting mode now.
but is it Kelly Ryder that you said no longer works at WellPath?
She does not work there anymore, but since I've been here, I've been an NCCI Gardner for almost 5 years. I think there's already been 4 health service administrators here during those 5 years. It changes yearly, it seems. I just don't want to be in front of another health service administrator begging for proper medical care.
Okay, well, I think that we understand your argument, but you still have some time. And so is there anything else that you would like to tell us or anything else you would like to add to what you explained so far?
So the motion judge in Superior Court, he gave all inferences to the defendants in this case. He relied on this made-up WellPath policy that I think I've hopefully shown that it wasn't a policy. It was a guideline. It was a practice. But the judge literally stated on page 6 of his memorandum of decision and order, and you can find that on page 119 of the plaintiff's record appendix, that he literally stated that they weren't going to go and give me the medical prescribed footwear because they were following a policy. He erred in stating that. There was no policy that he was citing there. And I believe that would make his argument to dismiss this case, it should be overturned. And as evident that there was no policy, I received the sneakers before and after. And if the motion judge didn't rely on the made-up WellPath policy, I should have at least survived the motion to dismiss stage and would have been able to continue on and receive discovery and been able to depose the defendants on their conversations and consultations with each other. I would at least been able to present a plated inference that would have given my complaint the credit it should have received and should have survived the 2-pronged test as cited in Estelle versus Gamble, 429 U.S. 97, 1976. I believe the motion judge was simply mistaken on his reasoning. And on top of that, when I spoke with the defendant, Dr. King, during my last consultation with him, I informed him that WellPath was giving me the sneakers previously, and then I informed him that the nurse practitioner at NCCI informed me that Kelly Ryder was doing away with sneaker orders. When I informed that to Dr. King, he says, "Oh, I'll go back and I'll talk to Kelly Ryder about this." I don't know if he ever did. Because nothing changed until I went a couple of weeks later and they told me, yeah, there was nothing new in your order. It wasn't until 3 months later after I filed a grievance and after the grievance was decided that Dr. King all of a sudden changed his prescription to these gel soles that they wanted me to wear that he already previously determined not to relieve my pain. I went through all that with him. They changed my order without even consulting with me. I don't know what they spoke about. And that's why I wish that this case could continue on so I can depose them to find out why he changed that order, why she told him to change that order, and why it wasn't changed until after I filed my grievance. And it was changed after that, literally the day after they decided on my grievance, they put in and changed my prescription. to something that already was tried before and he determined to fail. So I would
Can
hope
I-
I'd be able to depose. Yes.
Can I just ask you a very specific fact question? You say you tried that before. Did you try the Pro-Pay sneakers with a gel cup insert?
Yes, Your Honor. I've been seeing Dr. King since I think 08, 09. It started off with cortisone shots. He gave me about 10 cortisone shots over like a 5-year period, which he shouldn't have even done then. As I'm going through the records, because I never had the records until I started suing them, he tried everything: gel insoles, sleeves, Pro-Pay sneakers. He tried everything, and it was up to the point where this became an issue because I was always okay to buy my own sneakers. That was never an issue until recently. And it wasn't until WellPath had to provide me with the sneakers that Kelly Ryder decided not to do it anymore.
And just an odd little specific question. If Under Armour had made sneakers in size 16, do you think they would have worked?
I would have tried them. And that's what I explained to Jesse Hammond. I said I would buy them if they brought them in my size. And he said he was going to contact the Canteen Corporation to see if they sold them in my size. And they came back and told them that they didn't. So I request that this honorable court overturn the granting of the defendant's motion to dismiss and send this complaint back to the Superior Court for further proceedings. And I just like to thank you all for listening to me today. I appreciate it.
Okay, well, thank you very much for your argument. We'll turn now to Attorney Long.
Members of the panel, may it please the court. My name is Attorney Rebecca Long, and I represent Kelly Ryder, Lisa Shaluko, Charles King, and WellPath. And this case is about a disagreement in the treatment plan for appellant's feet. And I'm asking that the court affirm the lower court's ruling for several reasons, two of which I'd like to discuss here today. The first, that the lower court correctly dismissed appellant's 8th Amendment and Article 26 claims, where he failed to sufficiently allege that he received inadequate medical care or that the appellees acted with deliberate indifference. And second, the lower court correctly dismissed appellant's due process claims, where he failed to sufficiently allege that he had a protected property or liberty interest, which he was deprived of without appropriate process. And I'll start with the 8th Amendment and Article 26 claims, which in order to succeed on these claims, appellant is required to sufficiently allege both the objective and the subjective prong. The objective prong requiring a showing that he had a serious medical need, which he received inadequate medical care for, and a subjective prong, which requires a showing that the appellees acted with wanton disregard to his health. This is deliberate indifference.
Let's start with the first prong, and tell me how it is that, in your view, that the judge was correct that that prong was not.
So the objective prong requires proof of a serious medical need, which, if we were to assume that appellant has here, he then has to show that he received inadequate medical care, which, according to the facts of this case, he received adequate care. He was seen by Dr. King starting in 2008. Over the more than 10 years.
The allegation is that he received an appropriate prescription for a certain type of sneakers that alleviated pain, and that was changed with everybody knowing that he'd already tried the new prescribed treatment before, and it had been unsuccessful. So why doesn't that qualify?
So he didn't submit an order for these medically recommended sneakers. It was just part of the treatment plan for appellant to go purchase these sneakers from the canteen. When he requested to do this, he was informed that he couldn't purchase the shoes from the canteen. The nurse reviewed his medical record and saw that there was no order from Dr. King. They then contacted Dr. King, who determined that he didn't need medically ordered sneakers and that the specific brand of gel insoles, which he could use in a pair of sneakers of his choosing, would be sufficient. There's no allegation that he tried these gel.
But if we, at this stage of the proceedings, read the facts in favor of the plaintiff, why isn't Mr. O'Brien correct that there's a disconnect between the two prescriptions, if you will, from Dr. King, that after many years of trying to solve the problem, they settled on something that worked. And then when he was unable to purchase the sneakers he wanted, a prescription comes back from Dr. King saying, no, I think this solution will work. When, according to Mr. O'Brien, that solution had been tried and failed.
So just because something had been tried years prior doesn't make it deliberately indifferent to suggest that he tried again. There's no allegation in the complaint that he in fact tried it and it didn't work, and that he informed Dr. King that it didn't work, and then they refused to amend that order. All he alleges is they changed the treatment plan, or he submitted an order suggesting that he try something again. And he didn't approve.
Can I interrupt for a second? Because, and I'm just saying, doesn't that sound rather silly? Why would a patient have to try something again that didn't work before?
Well, several years has passed since he had tried it. That
Okay.
his condition could have changed, and that he didn't prescribe that these gel insoles be used with prop head shoes. He prescribed that these gel insoles be inserted into a pair of sneakers of appellant's choosing. It wasn't a specific shoe that he needed to use these gel insoles with.
Okay.
And it was a different brand of gel.
Is that the point where you say is actually something different than that by prescribing the gel soles within that sneaker? That's a different than something that had been tried before. Is that your view? Okay.
Yes, Your Honor. It was to try these gel insoles in a new pair of sneakers that he could purchase from the canteen.
Now, can you, before we get back to the fancy legal issues, could you just explain why WellPath cares about a situation where an inmate is willing to shell out his own money for something that he sees as solving his medical issue? It's not hard to order a new pair of shoes on, say, Zappos. Mr. O'Brien says this was a profit issue. I don't see profit involved. If you have to make an exception and you let Mr. O'Brien pay for it, where's all this coming from?
Yes, Your Honor, and I agree that this isn't a profit issue. It was determined that DOC was no longer going to allow inmates to purchase medically recommended sneakers from the canteen, and the medical vendor doesn't provide or didn't feel that this sneaker at that time was required, and they provided him with an alternate treatment plan.
So I guess it goes back to DOC's decision that inmates should no longer be permitted to purchase medically approved footwear. And do you know anything about the background of that? Why that?
So it's my understanding that one of the reasons may be a security risk, that some inmates are able to purchase some sneakers from the canteen and others can't. And then there's a discrepancy as to who has what, and that poses a security risk. That is my understanding, but I'm not DOC. I can't speak for DOC.
No, we appreciate that. We understand the qualifications on that.
Yes, Your Honor. So I'd argue that in this case, where they provided a sufficient alternate treatment plan, they all worked together to come up with this plan, that was sufficient. And I understand that appellant didn't like that treatment plan, but he doesn't allege that he tried it and it didn't work, and then they refused to make further amendments to that plan. Maybe it wouldn't have been the Nike sneakers that they would have ultimately recommended, but that doesn't mean that they wouldn't have recommended something different ultimately.
He also accept that Mr. O'Brien's point that we should infer from his complaint that he tried the insole and orthopedic shoe route previously. It did not work. That we should infer from the complaint that the sneaker route that he originally obtained from Dr. King did work. Then under those circumstances, how is that a choice between two sort of equivalent treatment plans where one works and one is demonstrably not successful? How is that not to Mr. O'Brien's point?
Well, this was a new gel insole, which was going to be inserted into a new shoe. So it was different than the prior order. And just because one sneaker works doesn't mean that something else couldn't work also. And there's no indication that he tried this gel insole in 2021, submitted a grievance saying, this didn't work for me, can I try something else? And they refused to change the treatment plan or work with him to come up with a new plan that did work. He didn't want to try the gel insoles in 2021. He wanted the Nike sneakers. So had he tried them and submitted a request, there's no reason to think that he wouldn't have received a different pair of sneakers. Maybe not the Nikes he wanted, but there's no reason to think that they wouldn't have been able to work together to come up with a plan that was available and would meet his needs.
So how was WellPath able to provide Mr. O'Brien the Nike sneakers? If the OC had a policy, you can't do this, and now.
Yes, Your Honor. So DOC had a policy that appellant couldn't purchase the sneakers on his own. It doesn't mean that a medical provider couldn't order the sneakers and then provide it to appellant. So it's my understanding, based on the fact of the complaint, that they were going to try these gel insoles first and then go from there. So if in fact the gel insoles didn't work, he could then have a discussion with Dr. King or another provider at the institution who could have determined what was required and ordered those sneakers for him.
I'm going to follow up on that question and ask a slightly different one, which is, there is an allegation in the complaint, which we have to accept as true, that Mr. O'Brien wasn't involved with that decision. In other words, the fact that he thought that he read a prescription for the sneakers, was planning on buying them, then he finally couldn't. Things got changed, and now there was a new prescription that was given for this gel soles, and he's claiming that that he was not part of that. That's the allegation. And then he's also claiming that had this a complaint not been dismissed, he could have had the opportunity to have some discovery, and he would find out exactly what happened. What do we do with the fact that his allegation is that he wasn't that wasn't addressed with him?
Yes, Your Honor. So he was informed that there was no treatment order that was submitted by Dr. King after his August 2021 appointment with him. He knew that before he submitted his grievance. Because of that, HSA Ryder and Lisa Shaluko had a discussion with Dr. King and said, you know, there was no treatment order here. What does he need? Does he need these medically ordered sneakers? Does he need something else? What is sufficient to meet his needs? Dr. King said, no, he doesn't need the medically ordered sneakers at this point. These gel insoles should be sufficient. He can insert them into the shoe of his choosing, and we can go from there.
I'm interrupt you because I understand that. I understand that that's part of the narrative that's in the record. I understand that, but there's still an allegation that, assuming all that happened, as you just summarized, that decision by Dr. King, oh, the gel soles will be okay for now, he wasn't involved in that decision. And what do we do with that allegation?
Yes, Your Honor, and I would argue that that doesn't mean that he didn't ultimately receive adequate medical care, or that any of these appellees acted with deliberate indifference towards his medical needs, which is what he was required to allege in an 8th Amendment or Article 26 claim.
Let me ask you a question that Justice Milkey asked Mr. O'Brien, which is about the potential mootness of this claim, since the sneakers have now been provided. I'd like to give you the opportunity to address that.
Yes, Your Honor, and I would also agree that this matter would be moot where he has since received sneakers. It sounds like he has continued to receive more than adequate medical care since filing this complaint. It sounds like he's undergoing surgery, or is going to be undergoing another surgery. And it's clear that he isn't not receiving medical care. He's seen often, he receives different treatments based on what his needs are at that time. He's involved in the treatment that he receives. There's a back and forth about what he needs and how he's going to get it. And there's no reason to think that that isn't the case going forward.
Right. Is there anything else you wanted to add in terms of summarizing your argument? I think that we understand all the issues, and the panel, I believe, does not have any further questions. Anything else you would like to add before you conclude?
No, Your Honor, if that addresses your questions, then I'll rely on the papers.
Okay. Am I correct that Justice Milkey, Justice Hand, there are no further questions? Okay, great. Well, thank you both very much for your arguments. We appreciate it, and we'll take the case under advisement. Thank you.
Thank you.